Alison Breiter, an employment attorney at Farah Farah.
And you recently had an employment case just settled for more than 6 figures. Can you kind of break down the case and who our client was?
Sure. So we had a client. She was very young, minimum wage earner, and she had a disability, and she sought accommodations for that disability, and she was shortly thereafter terminated. Of course, the employer made reasons of poor performance, different reasons for the termination. We were able to show that that was not the fact and secure her a settlement where she was able to manage her disability, find another position, and it was such a good settlement for her that she was able to purchase her first home. So it was life-changing for her, and she was very happy.
How did the company, really go after her, like kind of make it feel like they didn't really care about her, and you had to combat that a little bit?
In these types of cases, when people have a disability, it is under the ADA, the Americans with Disabilities Act, and she needed a certain accommodation to perform her job duties efficiently and effectively, and it was not going to cause the employer undue harm to them or anything like that. But they denied that accommodation, and then they start, slowly trying to squeeze her out, things of just making it more difficult for her. And then all of a sudden they find performance issues and then terminate her. So if it's within a certain amount of time of engaging in a protected activity, such as requesting a medical accommodation, then we might have a retaliation claim as well. And so we were able to tie that all together for her.
Can you break down why a company would deny accommodations for somebody like that?
So it depends. Sometimes the accommodation would cause the employer an undue hardship. So they aren't legally bound to give every accommodation. They only have to engage in an interactive process to determine whether they can or can't provide that accommodation. If they can't, and they can show it's a legitimate hardship on them, then she might not, she would have to decide if she can perform her job duties without that accommodation or not. And if she can't, then it wouldn't necessarily be an illegal termination.
Can you kind of break down like how that made our client feel, almost fired for just her life, like
Right.
basically what, the situation she was in?
She was scared. She was, and again, being a young woman with a disability, sometimes it's harder for her to understand with the type of disability she had. So she was very scared. She didn't understand. So we were able to explain things to her and guide her through the process. But it made her feel like she didn't matter. Like she had given this employer, several years of her life, and then she felt like they just threw her away when they wouldn't help her.
So if somebody were in a similar situation, would you recommend that they do seek, legal advice from an attorney?
Absolutely. Absolutely. I think seeking an employment attorney early on is the best thing an employee can do when they start having issues, because sometimes if you wait too long, it might be too late. There's deadlines, statute of limitations, things that might run. And we can also, even if they don't have a viable claim at that time, we can help explain to them, if this happens or this continues to happen, call us back. But we can walk them through what their legal protections are so that they know.